Good morning and welcome to the Judicial Committee of the Privy Council. This is an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court. It raises a question of the company law of the British Virgin Islands relating to the just and equitable winding up of a holding company, Ocean Sino Limited, on the basis that the management of the company is deadlocked because of disagreement between its two shareholders, Mr. Lau and Mr. Chu, each of whom own 50% of its shares. Mr. Justice Kay ordered the winding up of the company on the just and equitable ground, but the Court of Appeal set aside that order and Mr. Lau now appeals to the board. I will introduce the members of the panel before introducing counsel. I am Lord Hodge, and I'm presiding today. Lord Briggs. Lady Arden.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
Today, Mr. Lau is represented by Philip Jones QC, assisted by Daniel Warrants and Sparsh Garg. Mr. Chu is represented by Richard Hacker QC, assisted by John Carrington QC, William Wong QC, and Michael Locke. I will now invite Mr. Jones to begin his submissions on behalf of Mr. Lau.
Good morning, my lords, my lady. As you'll have seen, there's quite a bit for me to get through in the allotted time, and I'll have to take some of the points at speed. We are, however, having daily transcripts made of the submissions, which will be provided to the board, so you will have a full written record of the oral submissions. I hope that will help. I need to make...
Jones, you can take it that the members of the board will have read the judgments below, the written submissions of the parties as well, so you can assume that we are aware of that material.
Thank you. One preliminary point. There's been no application to adduce fresh evidence since the first trial, and there's no affidavit evidence which deals with subsequent matters. I'm therefore going to ignore anything that's occurred subsequently that's referred to in any case. This case has to be decided on the basis of the evidence before the judge at the trial in May 2017, and the board has to put itself in the position of the judge that he was in at that time and determine whether his order should stand or fall. By way of introduction, I just want to outline the sort of questions that the court has to ask itself. Could I ask you to go to page 5248? We've got here the BVI Insolvency Act, and if I could just ask you to look at section 162(1) and B. The court may, on an application by a person specified in subsection 2, appoint a liquidator of a company under section 159, and then B, if the court is of the opinion that it is just and equitable that a liquidator should be appointed. With the exception of the use of the words applicant and appoint a liquidator, what I've just read out comes from the UK legislation as well, and it's been there for a long time, except the words petitioner and winding up order. But apart from that, the language is the same. And then if I could ask you to go to 5251. And if we could look at section 167(3). At the bottom of the page. So where an application to appoint a liquidator is made by a member under section 1621B, the one we've just looked at, if the court is of the opinion that the applicant is entitled to relief, either by the appointment of a liquidator or by some other means, and B, in the absence of any other remedy, it would be just and equitable to appoint a liquidator, it shall appoint a liquidator, unless it is also of the opinion that some other remedy is available to the applicant and that he is acting unreasonably in seeking to have a liquidator appointed instead of pursuing that other remedy. And again, with the exception of the two phrases that I've already told you about, that's the same in the UK legislation, and you find it in section 125, subsection 2. I'm not asking you to turn it up, but it's at 5341. These are all matters for the judge's opinion. We say that an appeal in relation to the forming of such an opinion in these provisions must, we say, therefore, be on the same grounds as an appeal against a discretionary decision. Can I next ask you to go to 5349? This is a passage from the judgment of Mr. Justice Weinlott in Rea Company, and if I could ask you to look at letter H. And my Lord Hodge, what I'm going to do with passages is invite you to read them rather than to read them out. Is that satisfactory? So could I just ask you to read the paragraph at letter H?
Yes, yes.
So in other words, what the judge is there saying is that you read the word remedy, not limited to a legal remedy, but in effect to any solution to the problem posed in the application. I confess I've vacillated as to whether I should be supporting that or opposing it. I don't think it makes much difference, because even if in fact what the statute is referring to as statutory remedies, there's obviously an overriding discretion. And if a reasonable offer has been made and it's unreasonable for the petitioner to pursue it, then the petition should be dismissed. But I think my present view is that that is probably the right way to look at the legislation, so that what the second question is dealing with after the word unless is any remedy or solution to the problem that the applicant is complaining about. Now, the next issue I want to look at is where the onus of proof lies. Obviously, on the first question, it lies on the petitioner applicant. If we could look at 729. I'm sorry about the quality of the photocopy here, but if I could ask you just to read the passage from the paragraph from A to C, and by way of introduction, section 111 bis is the South African equivalent of the unfair prejudice relief, and section 117.2 is what we've just been looking at in the BVI legislation. And before I comment on that, can we just also look at a Queensland Court of Appeal decision to the same effect? So if we go to 5406, and if you can, there are two paragraphs I'll take you to in this judgment. If you can first just look at paragraph 32.
Mr. Jones, I'm very happy that you ask us to read the material, but in case there are people listening in who don't have access to the judgment, if you could at least mention the name of the case that you're referring to, so that people can know how the debate is developing. Thank you.
Of course, I'm sorry. This is a case called Asia Pacific Joint Mining.
Thank you.
Mr. Jones, I think I got the page number down wrong, the bundle page number.
5406.
Thank you.
At paragraph 32.
At paragraph 32, yes.
Thank you.
I said there's a second paragraph, which is at 5410. And it's the top paragraph, paragraph 43. Obviously, neither of these decisions are binding on the board, but we say the reasoning is obviously correct. And it follows from the wording of the legislation. So what a judge first has to do is to form an opinion whether, in the absence of any other solution to the matters which form the basis of the complaint, it would be just and equitable to wind up the company. The onus here is on the applicant. If the applicant satisfies the court of this, the onus is then on the respondent to persuade the court to form an opinion that there is an alternative solution available to the applicant and that the applicant is acting unreasonably in seeking to have a winding up order instead of that alternative solution. Of course, I accept that the burden of proof is a tool of last resort. Nevertheless, the burden of proof is also the first port of call and dictates who has to put forward what. So in the absent other remedies, if absent other remedies it's just an equitable to wind up a company, it's for the respondent to put forward what alternative remedies the respondent contends are available and why the applicant is acting unreasonably. These obviously, if there are pleadings, have to be set out in the pleadings. If there's evidence, it has to be set out in the evidence. So I'm now going to go on to consider the first question, namely whether in the absence of any other solutions or remedies to the problems identified, it would be just and equitable to make a winding up order. Can I then move on to just deal with some of the legal issues? Now, there is nothing in the memorandum or articles of association or in the general law that permits a shareholder in the position of Mr. Lau, a shareholder holding 50% of the shares, unilaterally to put a company such as OSL into liquidation. Section 159 of the Insolvency Act, which we've got in the bundles, provides that the members may, by a qualifying majority, put a company into liquidation. A qualifying majority is a majority of 75% of the votes of those members who are present at the meeting and entitled to vote on the resolution. So the issue is, notwithstanding that Mr. Lau has no right unilaterally to put OSL into liquidation, whether it is nevertheless just and equitable that OSL should be put into liquidation. That, of course, is the issue on every just and equitable winding up application. It's only resorted to because the applicants cannot themselves unilaterally put the company into liquidation. Now, you will have seen from our written case that we've identified two strands of authorities which are relevant to the present case. They're set out in detail. I know you've read the written case, and I'm not going to go through those authorities. Of course, the first is whether there's a deadlock. What these authorities establish is that a deadlock potentially engages the court's jurisdiction to wind up a company on the just and equitable ground. Now, there's no requirement in those cases for the company to be a quasi-partnership. The second is where the court applies by analogy the principles developed in partnership law for ordering the dissolution of a partnership. The principle is potentially engaged where one has a company in the guise of a partnership, or what is often referred to as a quasi-partnership. It's not necessary from those authorities that there is in fact actually a deadlock. But I entirely accept that one has to be very careful when using the term quasi-partnership. It should not be used as a fixed legal category from which, if you come within that category, certain legal consequences follow. Ultimately, what one has to do is to ask whether circumstances have existed or have occurred from which the court can apply equitable considerations to or restraints upon the black letter of the memorandum and articles of association. It's highly nuanced and depends on the particular facts of each case. I'm not going to ask you to go to it, but Lord Wilberforce in Ibrahimi said at 379H, which is at 6096, that the term may be convenient, but may also be confusing. And my Lady Arden in Strahan and Wilcox, which is in our supplementary bundle of authorities, at internal paragraph 18, bundle reference 109, which I don't need you to turn up, said the term quasi-partnership was not always a helpful label. And I entirely agree with that. Nevertheless, despite that, I'm going to use the term quasi-partnership as shorthand to describe what I think we all know we're talking about.
Yes, the judge made a finding in this case that we were dealing, as far as OSL was concerned, with a quasi-partnership circumstance. But
Yes.
Most of his judgment then dealt with deadlock.
It does.
Will you be submitting that on a separate strand of quasi-partnership, the bringing in of equitable considerations, that was a ground on which he appointed the liquidator or not?
Yes, in fact, I'm 4 paragraphs down. I was going to go to the paragraphs in the judgment to take you through, because actually what he decides it on is that there's a deadlock, but he effectively says this is also a quasi-partnership, and all the grounds that would lead to winding up on the quasi-partnership ground are equally applicable here.
Thank you.
All I was going to do in the interim before I go to that, if I may, is just ask you to go to 8154. This is from the Yenergy judgment in the Court of Appeal. And if I can just ask you to go to the second paragraph, where he says, Asbury J dealt with this case, as it seems to me, in a most satisfactory way. And then if we go down 5 lines, you get the line, if ever there was a case of deadlock, I think it exists here. But whether it exists or not, I think the circumstances are such that we ought to apply, if necessary, the analogy of the partnership law, and to say that this company is now in a state which could not have been contemplated by the parties when the company was formed, and which ought to be terminated as soon as possible. So he does consider that on the facts of the energy, that this was a deadlock, if ever there was one. But he says that, we can also apply we can go straight to the partnership analogy provisions as grounds which make it just and equitable to wind up the company. And then what I was going to do was to go to the parts of judgment. So if we go to page 10 of the electronic bundle, I know you will have looked at this, but it's paragraphs 28 and 29. And if we start halfway down 28, do you see the words, each expected to participate in the management of their various ventures? If I could ask you just to read the end of that paragraph and read the next paragraph, paragraph 29. So the judge made an express finding that this was a quasi-partnership. And then if we go to page 30 of the electronic bundle.
Would I be right in saying, Mr. Jones, that wasn't challenged by the Court of Appeal, that finding?
Well, it's difficult. If you look at, I think it's probably paragraph 64 of their judgment, what they say is that this was a commercial contract between the parties.
Yes.
And it may well be that that can be read as saying that it doesn't fall within the quasi-partnership category.
Yes.
But they don't deal with the judge's findings. They don't, as it were, analyze them and say why he got it wrong.
Well, that was my understanding.
Yes.
That was my understanding. I was aware of that passage, which seemed to contradict it, but they didn't set up any reasoning for departing from the judge's finding.
No.
Thank you.
So then, just to complete what the judge says, I think we need to look at 86 to 89. I know you'll have read this, and therefore you'll be able to go through it quickly, but 86, hopeless state of deadlock. No realistic prospect of them getting on together, hardly on speaking terms. And then 87, he said there was much arid argument as to whether deadlock could justify a case of liquidation on the just and equitable ground in the absence of a plea or evidence of a quasi-partnership. He holds that it's not necessary for it to be a quasi-partnership. But he then goes on saying, in any event, so far as OSL was concerned, I am more than satisfied that their relationship did amount to a quasi-partnership. And it was a situation that had become one that each did not contemplate when OSL was launched. And that uses the language in Yenergy. And then we've got the argument put forward by the other side in 88 and 89, which he rejects. So then if we can just go to page 34. At 99. He concludes that the relationship is irretrievably and permanently totally deadlocked, such that they cannot reasonably be expected to get on with each other at any level, personal, board, or shareholder. They're deadlocked. And perhaps just quickly, if I can ask you to go to 5197 from our case. No, that's a row, sorry, 5197. I've typed in the wrong number. What you'll see there in paragraph 12, we've set out the various cases that Mr. Chu has brought in which he describes the relationship as a quasi-partnership. So that's Mr. Chu's description of the relationship. So drawing all that together, Mr. Justice Kay decides that this is a case of deadlock, just as Lord Curzon Hardy's thought was the case in Yenergy. The existence of a quasi-partnership was not necessary part of his reasoning, but he goes on to say that it in any event is a case of quasi-partnership, and that a situation has occurred which could not have been contemplated when OSL was launched, but it would be just and equitable to wind up the company. Now, of course, one's got to be very careful not to treat these different strands of authorities as if they form some separate legal categories justifying winding up. They're not separate subsections set out in the legislation. And if we could just go to a short passage from Lord Wilberforce's speech in Ebrahimi, 6091. If we look at letter H, he says, first, there has been a tendency to create categories or headings under which cases must be brought if the clause is to apply. This is wrong. Illustrations may be used, but general words should remain general and not be reduced to the sum of particular instances. Lord Wilberforce's warning not to treat the different strands of authorities as their separate categories applies equally to both the deadlock strand and the quasi-partnership. There is no statutory definition of these terms, including deadlock. It's for the trial judge to determine whether there is now a state of affairs which could not have been contemplated when the company was established, that prevents the company from properly functioning as it should, such that, in the opinion of the judge, it's just and equitable to wind up the company. And if we can go to 6093, that's just over the page from the passage we've just been looking at. And if we could look at Ceta E, this is Lord Wilberforce commenting on the Yenergy case. He says, he describes what it is, and then he says, it has often been argued, and was so in this House, that its authority is limited to true deadlock cases. I could in any case not be persuaded that the words just and equitable need or can be confined to such situations. So, there isn't something such as, well, it's got to be a true deadlock, whatever that might mean. Lord Wilberforce considers, it's wider than that. And then, of course, he goes on to deal with the passage that we've just looked at. And again, if I can just ask you to go to 5721. And this isn't the right reference, 5721. Sorry.
Is it that's the case of Chow and Chow?
It is. Something's just happened, and yes, it is. And it's from the Singapore Court of Appeal, Chow Kwok Chuen, and it's just the top paragraph. Again, that just illustrates the point I'm making, that one has to be very careful about not having hard-lined, defined categories here. Ultimately, the issue is whether it's just and equitable to wind up the company. These, of course, are predominantly questions of fact, both past fact and future prediction. The question is, if the petition is not allowed, are these parties capable of cooperating in the future? And emphasizing the sort of questions that a first instance judge has to look at, if we could go to page 5121, and this is from our written case. And I wonder if I could just ask you to refamiliarize yourselves with 151 and 152, and particularly the passages in the judgment of Lord Donovan.
I'm sorry, Mr. Jones, can I have that page number again?
Yes, 5121.
Thank you.
And if you could just quickly refamiliarize paragraphs 151 and 152. Those are the sort of issues of fact which are for the trial judge. Questions such as, should they treat a mutual misunderstanding as if there'd never been one? Has the relationship reached a stage of such continued quarrelling and animosity that precludes all reasonable hope of reconciliation and cooperation if ordinary good sense is employed? Is it impossible for them to resolve their differences and carry on with the spirit of cooperation that they've done for many years? Those are primarily questions of fact. I'm going to move on to a separate topic, which is a discrete issue relating to the ability under the memorandum and articles of both Mr. Chu and Mr. Lau being able to transfer their shares to a third party without the consent of the other. The respondent, Mr. Chu, relies on this in two respects. First, he says that the ability to transfer the shares without restriction means that the relationship in respect of OSL was not a quasi-partnership. And second, he says that the ability to transfer the shares meant that there was an alternative remedy available to Mr. Lau, and that he has acted unreasonably in seeking a liquidation order rather than selling his shares to a third party. Now, none of this was put to the judge in the closing submissions, and none of it forms any part of the pleaded defence. The evidence took place between the 2nd and the 9th of May 2007. The case was then adjourned to the 16th of June for oral closing submissions. The parties were required to provide written closing submissions by the 9th of June. So there was a whole month to produce closing written submissions. The respondents' written submissions and appendices consisted of over 200 pages. Despite that, at no point in those closing submissions did the respondent, Mr. Chu, refer to the ability to transfer shares to a third party under the Memorandum Articles of Association. At no point did Mr. Chu ask the judge to take this into account in determining whether there was a quasi-partnership or in relation to whether this provided an alternative remedy which Mr. Lau ought to have pursued. None of this was in the pleaded defence. There was no exploration of the significance of this in cross-examination by either party. That was because it wasn't an issue. This was all pointed out to the Court of Appeal, but none of that is reflected in their judgment. As my Lady Arden said when giving the advice of this board in Shanda Games, the general rule is that it's not open to a party to criticise a judge for failing to take something into account if that judge was not asked to take it into account. There's no good reason here to depart from that general rule. In any event, I'll make a few, hopefully quick points about whether there was a quasi-partnership, and I'll deal with the ability to sell as an alternative remedy when I come on to the second question later. In the energy, the articles relevant to the case are set out in some detail and I'll just give you the references, 8148 to 9, and in the judgment of Lord Cosens Hardy at 8151 to 2. There's no reference there to there being any restriction on the transfer of shares. Had there been such a restriction, one can be fairly sure it would have been referred to. And then we come to the well-known passage in the speech of Lord Wilberforce and Ebrahimi. So if I could ask you to go to 6096. And it's the passage at E to G. So he says it's impossible and wholly undesirable to define the circumstances in which these considerations may arise. And then he says it typically may include one or probably more of the following elements. But under Roman numeral 3, the restriction upon the transfer is obviously not a sine qua non for a quasi-partnership. And of course, this was as far as I'm aware, the first leading case that, as it were, dealt with what we're now calling quasi-partnership. But of course, for those of us who practice in England, since 1980, you've had the unfair prejudice remedy, many of which cases turn on whether, in fact, there is a quasi-partnership. So there have been many, many cases, and it's come realistically to the extent it's a bit like an elephant. You may not be able to give a precise definition, but you generally know one when you see one. And we've put into the supplementary bundle the decision of the English Court of Appeal in Strahan and Wilcox. It's at page 111 of the supplementary bundle. If you don't want to go to that, I can just read out the short passage that I was going to refer to in my Lady Arden's judgment, where she says, the question whether the relationship between shareholders constitutes a quasi-partnership is relatively easy to answer if the company's business was previously run by a partnership in which the shareholders were the partners. It's indeed common for partnerships to be converted into companies for tax or other reasons. It's also relatively easy to establish whether a relationship between shareholders constitutes a quasi-partnership when a company was formed by a group of persons who are well known to each other, and the incorporation of the company was with a view to them all working together in the company to exploit some business concept which they have. Of course, we say this second example is precisely what has happened here. And we've set out, again, I'm not going to take you to it, but paragraph 9 of our reply submissions, we refer to authorities which make it clear that a restriction on the transfer of the shares is not a precondition for the existence of a quasi-partnership. But of course, in the present case, we say in any event, there is a practical restriction on the transfer of the shares because neither would be likely to find a buyer at a price equal to 50% of the value of OSL, because the purchaser would have no right to appoint a director. Control would remain with the remaining shareholders and directors. I now need to move on to deal with two issues of law. The first is whether Mr. Lau has to make out his case solely by reference to conduct in relation to OSL or PBM. The second issue is whether Mr. Lau is restricted to relying on matters that had occurred prior to the bringing of the proceedings. Ultimately, in fact, neither of these matter, because the judge specifically found that at the date the proceedings were commenced, there was an irretrievable breakdown. And secondly, when you analyze the incidents of the breakdown, they are one way or another all connected with the general dispute that includes OSL. So neither of these are actually decisive, but I do need to deal with them because the Court of Appeal appears to put some weight on put some weight on it, and certainly my learned friend puts a huge amount of weight on these two issues. So the first is the contention that an applicant in the position of Mr. Lau must make out his case solely by reference to conduct in relation to OSL or PBN, and that it's not permissible as a matter of law to take into account matters that have occurred in relation to any other company, whether that be Babel Gulf or any of the collateral companies in which they have an interest. Now, what one needs to, where you have a two-person company, if there is a breakdown in the relationship or a deadlock that results in the company being unable to function as a company, should or was envisaged, then we say it does not matter what has caused the deadlock or the breakdown. It is the fact that a deadlock or breakdown has occurred which prevents the company from operating as it should. The two authorities which were urged on the Court of Appeal, and which are both referred to in the Court of Appeal's judgment, are Locke and John Blackwood, a decision of this board, and Union Zone, a decision of the Eastern Caribbean Court of Appeal. Neither of these cases were deadlock or quasi-partnership cases. We can probably take this up from our written case at 5104. We've there got the section where we deal with Locke and John Blackwood. And we've set out the facts. It's not a deadlock or a quasi-partnership case. And if you go over the page, you'll see the passage that's often relied on in many cases. It's undoubtedly true that at the foundation of applications for winding up on the just and equitable rule, there must lie a justifiable lack of confidence in the conduct and management of the company's affairs. But this lack of confidence must be grounded on conduct of the directors, not in regard to their private life or affairs, but in regard to the company's business. Furthermore, the lack of confidence must spring not from dissatisfaction at being outvoted on the business affairs or on what is called the domestic policy of the company. On the other hand, whenever that lack of confidence has rested on a lack of probity in the conduct of the company's affairs, then the former is justified by the latter, and it's under the statute just and equitable that the company be wound up. So it's often that passage that's quoted that says, well, it has to be something to do with the justifiable lack of confidence in the management of the company. But of course, this wasn't a deadlock or a quasi-partnership case, and Lord Wilberforce himself points that out in the passage that we've set out at paragraph 82. And in paragraph 83, obviously when he says it's not one of deadlock, he's also including the quasi-partnership cases because he's referred to Symington and Yenergy. And the point Lord Wilberforce is making is that the board in Locke and John Blackwood extended the just and equitable jurisdiction to include a case where the company was not deadlocked and where there was no quasi-partnership, but there had been a lack of probity on the part of those managing the company in circumstances where the constitutional organs could not be used to remove them because they were in the majority. And then briefly go to Union Zone 5108. We're taking this from our written case, and you'll see that our discussion of the Union Zone starts at 92. I know you've read this, but again, it's not a deadlock or quasi-partnership case. And the passage over the page, so if I ask you to go to paragraph 95, the passage from the judgment of Justice of Appeal Ferrara at 67 is what the Court of Appeal in our case expressly relies on. If I could just ask you to just familiarize that. And you'll note at the beginning, of course, they draw no distinction between the holding company and its subsidiary. And although it's not always entirely clear from the Court of Appeal's judgment, there is no practical way to distinguish PBM from OSL. Although OSL is just the holding company, the cause of the breakdown at the PBM level, the cause of that is the inability to solve it at the OSL level. Because if OSL had independent shareholders and Chu and Lau were quarreling at the PBM level, well, you could just sweep them from the board or appoint a majority. It's the breakdown between them which means that OSL can't solve the problems at the PBM level, that's the heart of the case. However, for the reasons, as I said, what the judge was dealing with at that passage in 67 was not a deadlock case. And if you go down to paragraph 97 of our written case, he recognizes that. He says the breakdown in the relationship between shareholders is not in of itself justification for winding up a company. For such a state of affairs to arise to the level of a just and equitable winding up of the company, it must represent or lead to deadlock on the board or between the shareholders in general meeting. And he then goes on to deal with the other position. So he wasn't considering a deadlock company. And we say these weren't relevant to deadlock cases because the issue in a deadlock cases is whether there's a deadlock, not the reason why the deadlock has arisen. And we gave examples to the Court of Appeal. So if I can ask you to go to 5101. And we start at paragraph 68, where we make the point there that I've just made to you. You can go over to 69 onwards. The examples that we gave, which we say demonstrates this point. The first one was a quasi-partnership with A and B as the only shareholders and directors. Assume that B has an affair or begins living with A's spouse, such that the relationship between A and B irretrievably breaks down. They can no longer work together. This obviously is a case which engages the court's jurisdiction to wind up the company. It doesn't matter that they haven't fallen out over the running of the business. It's whether the state of the relationship is such that the business cannot operate as it should operate. And then we give another example in 70. Assume you've got two separate quasi-partnership companies, what I refer to as collateral companies. They're not part of a group. So you've got X Limited and Y Limited, in which they're equal shareholders and the only directors. Assume that B misappropriates money from Y Limited, and that as a result, the relationship between A and B irretrievably breaks down such that they cannot work together in relation to either company. We say that would plainly engage the court's jurisdiction to wind up X Limited, even though B has done nothing wrong in relation to X Limited. It's the fact of the breakdown, not the reason for the breakdown, that is critical.
Could I ask you whether in the two cases mentioned in those two paragraphs, the court investigated the question of the cause of the breakdown of the relationship? I mean, in each case, you've told us what the cause was. I'm sorry, the one in 70 is just an assumption, a hypothesis, but in 69, did the court go into the reason why there had been an irretrievable breakdown?
When I made those submissions on 69, which I also did in front of Justice Kay, and I did in front of the Court of Appeal, I wasn't able to cite any authority in respect of that.
Oh, I thought there was an Australian case or a South African one.
There is. My second junior, Mr. Gard, managed to find those cases. And so as my lady has brought that up, if we can go over the page to 75, you'll see there's the reference there first to the South African case in which this exact issue arose.
Yes.
And you've got the two passages there from the case. And indeed, the very argument that's put against me was put to that court because Mr. Richards, well, first of all, it uses the language of 70 years ago, so that it says Mr. Richards was guilty of misconduct in having adultery with the wife of Mr. Lawrence. And I'll come on to that in a moment, but that's the language of the time. And the very argument was put, well, yes, that might be the reason that they fall out, but look at what Locke and John Blackwood says, which is that, well, it has to be to do with the management of the company. And he rejects that and says, no, it's the fact that they can't cooperate. And of course, he gives the reason for that, which is that Mr. Richards has had an affair, or committed adultery, to use that language, with Mr. Lawrence's wife.
But if the petitioner, I'm sorry, my Lord Legate's got a question, just to wind this up. If the petitioner who wanted the winding up had been the person who had had the affair with the wife, what would then have happened?
Well, I think that's where we would look at it through different eyes with today's morality. And what the court would say is that we're not going to investigate whose fault it is that Mr. Richards has had an affair with Mr. Lawrence's wife. Indeed, we know these days, these things happen, and it may be for the better. So what they would do today would just be to recognize that there is a breakdown in the relationship caused by an event which isn't to do with the running of the company. Now, of course, you've also got to remember that there is a gloss on everything that I've said, which is that if the applicant is the sole cause of the breakdown, then the applicant can't rely on that. But today, looking at this, one simply wouldn't go into the personal relationships between the three of them and say, well, he's had an affair. Let's assume it was Mr. Richards. And he said, well, he's had an affair with Mr. Lawrence's wife, and therefore he's the sole cause of the breakdown. You might have 70 years ago, but well, I just say you wouldn't today.
My point really doesn't turn on whether there's an allegation of adultery and how we would treat that today. But just on this question, you do accept that the question of responsibility for the breakdown is an issue?
Yes.
Which has to be considered?
Yes. Well, only to the extent that you can find at the end of the day that the sole cause of it is the applicant's. That's where the responsibility comes into it.
I see.
Because, one can't have somebody, as it were, pulling themselves up by their own bootstraps and deliberately creating a breakdown in the relationship in order to bring the case. Someone's always got to be careful with that. But short of a finding that the sole cause of the breakdown is that of the applicant, one doesn't apportion blame, one doesn't investigate fault, one just notes the breakdown. I'm sorry, my Lord, sorry, have you finished, my lady?
Yes, I have. Thank you.
My Lord Legate.
I just wanted to ask Mr. Jones whether there's a question of facts really involved, because there may be cases in which if the parties fall out over what you might call extraneous matters, that won't prevent them cooperating to the minimal extent they need to make this particular company function. But on the other hand, there'll be some cases in which their fallout is so total that although the cause of it is other matters, it prevents them from operating the company effectively.
My Lord, I absolutely agree. We all know from experiences in life that where there's a breakdown in a marriage, or even in the situation where the other one has run off with your business partner, some people will say, well, look, this is a good business. I'm going to put all this aside and I'm just going to get on with the business and forget all that. But there will be other extremes where they won't be able to do that, and the whole relationship breaks down because, understandably, they can't bear to be in the same room. So I entirely agree. But what the point I'm making is it doesn't have to be connected with the running of the business. In other words, it doesn't have to be something that the cause of it doesn't have to be a business dispute. So just go back to I think it's back to the next page, back to the previous page, 5102. The other example is this paragraph 71, which is similar to the structure that we have here. We assume that A and B have a quasi-partnership company X Limited, which has a 49% interest in Z Limited, and they're both directors of Z Limited, together with 3 directors from the majority 51% shareholder. Assume that B, without A's knowledge and consent, misappropriates money from the joint venture company, Z Limited. That, of course, would be to the detriment of X Limited's 49% interest. If, as a result, the relationship between A and B irretrievably breaks down, such that they can't work together in relation to X Limited, then that engages the court's jurisdiction. Again, it's the fact of the breakdown and not the reason for the breakdown that is critical. And one passage which I've overlooked, if I could ask you, I'll have to come back to it, but there is a passage from the judgment of, I'll come back to this sometime. There is a passage from the judgment of Lord Wilberforce which says, it isn't limited, it's any circumstances you take into account in the relationship between the shareholders. And then finally, 5105, at the bottom, we deal with O'Neill and Phillips. Sorry, 5106 is the relevant passage. No, this is O'Neill and Phillips. And then the relevant passage is the following page where we have the heading no fault divorce, where Lord Hoffman says no fault divorce is not part of our law. And then if I can ask you to go to yes, at 89, we explain that it's important to understand that Lord Hoffman is not there in any way casting any doubt on the energy deadlock line of authority. Indeed, he's based his judgment on Ibrahimi, which itself endorses the energy. And what we say is the reference to no fault divorce is a reference to a matrimonial legal system that permits a spouse to obtain a divorce at will without assigning any reason for the divorce and without the court inquiring into the reasons for the breakdown. Now, this is not what Yenergy is about. And the Yenergy, it's necessary to establish that there has been an irretrievable breakdown such that the company can no longer function as a company ought to function, and that this situation has not been caused by the applicant. The situation which Lord Hoffman was dealing with was where a member with a minority interest is excluded, but this does not prevent the company from properly carrying on business, i.e. where there is no deadlock. Although in the absence of the applicant being the cause of the breakdown, a Yenergy deadlock case does not require the court to inquire into fault, this is not the no-fault divorce category referred to by Lord Hoffman. The Yenergy deadlock jurisdiction does not establish a unilateral right for a member to take out their capital simply because they have lost trust and confidence in another member or in the management. There's nothing in O'Neill that calls into question the Yenergy deadlock line of cases. And perhaps finally, if we can go back to 5105, it's paragraph 84 at the bottom of this page. This again is our written case, but just to emphasize the distinction that has to be drawn. Where one is not dealing with a deadlock case between two quasi-partners, an irretrievable breakdown in the relationship between, say, a shareholder and a director will not prevent the company from functioning. If a director has an affair with the spouse of a shareholder, that will not prevent the company from functioning. The deadlock line of cases are dealing with those irretrievable breakdowns which prevent the company from functioning properly as a company should. An irretrievable breakdown which does not prevent the company from functioning properly does not without more engage the jurisdiction to wind up a company. One has to have something more. And I'm not sure I've got time to go through this, but at paragraphs 124 to 141, well, perhaps I'll just quickly skip through them. If we can go to 5115. And what we deal with here is the judge's analysis of the matters up to the start of the proceedings. So we start, no. All right. Bear with me. Right, we start at 5115. And you go down to the bottom of the page, pre-commencement facts and matters. We highlight what the judge's conclusion was at the time of commencing the proceedings, and you've already seen that. And just quickly look at the matters he deals with. The first one is the PBM loans, and it starts off with a dispute as to whether PBM's loans are capital or not. And Mr. Chu says they're capital, Mr. Lau says they're not. But what you have to identify is that the dispute here is over an asset of PBM. What the Court of Appeal said was, oh, this is all a dispute at the Beibu Gulf level. In one sense, the decision as to whether to repay the loans is, of course, a decision at Beibu Gulf. But the dispute between Chu and Lau, what Mr. Lau said, which the judge found was the correct analysis, was that these were loans which, when the purpose of the loans failed because the number of ships needed were not, some of them were cancelled, then the monies were repayable. So the nature of the dispute here was actually at PBM level. And at paragraph 129, we show where the Court of Appeal misunderstood what the dispute was.
So, Mr. Jones,
yes.
Sorry to interrupt you, but there was a finding, I think, by the judge at first instance at paragraph 36 that there were $38 million of loans by PBM, and those loans were repayable on demand.
Yes.
Yes. And again, was that traduced in the inner house, in the Court of Appeal?
Yes. Well, first of all, I can just qualify that. They're not expressly on demand.
No.
It was because the purpose had failed.
Yes.
They became payable on demand. Yes.
Yes, but you have a finding that they became repayable on demand. And as far as the dispute between Mr. Lau and Mr. Chu were concerned on that issue, Mr. Lau was correct.
Yes. We deal with it at paragraph 129.
Yes.
So it's at the bottom of the page that we're just looking at. We've quoted the relevant part of the judgment of the Court of Appeal. And what they say is the dispute and the main trigger of the winding up application was a disagreement as to whether Beibu Gulf should repay PBM. On any view of the facts, PBM only had minority shareholding in Beibu Gulf and therefore could not make any decisions as to what should occur in Beibu Gulf. As I've stated earlier, I do not see where any finding of deadlock would arise on those facts. Stripped to its barest, Mr. Lau, in his petition, was complaining about what was happening at the Beibu Gulf. It's worth emphasising that Beibu Gulf is not a subsidiary of OSL. I fail to see on what basis the learned judge could have held that there was deadlock in OSL. Well, as we say in paragraph 30, they've misunderstood the nature of the dispute. The nature of the dispute was as to what was the nature of the asset of PBM and whether PBM should demand its repayment.
Yes, because if there was a right to demand repayment, which was legally enforceable, the board of Beibu Gulf would have to accept that.
Exactly.
Yes.
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 And so yeah.
There's the point you're making is that the dispute was at the PBM level.
Yes.
Yes.
And then the next matter he deals with was, and we make those points in one.
Just so I understand, Mr. Jones, you say the disputes at the PBM level because if it was repayable on demand and if Beibu Gulf didn't agree, then the PBM management question would be whether it should take proceedings against Beibu Gulf to recover the money.
Exactly.
Yeah.
And the dispute is A, over the nature of PBM's asset. Was it capital or a loan?
Yes.
And B, whether if it was a loan, a demand should be made for the repayment.
Yes.
So these were PBM issues.
I mean, the nature of the investment might be said to be a sort of theoretical question, but there's a concrete management question which underlies it, which can't be resolved until the company's formed a view about the nature of its investment in Baibu Gulf.
Yes. And of course, the judge went on to find that actually there wasn't really any basis for this argument about capital. That if you went back earlier, it was low, and therefore he criticized Mr. Chu for that matter. But ultimately, the judge said he didn't need to go into the issues of fault. It was the fact that there was a dispute, and of course disputes occur, and that of itself may not be sufficient, but you have to look at it in the round of all the whole disputes that occurred here. And if we go on to 132 on page 5117, the Court of Appeal paid no attention at all to the failed attempts by Mr. Lau and Mr. Chu to separate their business interests. The judge deals with this in detail. He makes a series of findings about the failed attempts to agree on mechanisms for separating their business interests. They themselves are of the view they've got a pot company, but they can't do it. And then 134, and of course a critical reason for the failure of these attempts, which is identified by the judge at 47, was that Mr. Chu repeatedly fobbed off Mr. Lau from being provided with up-to-date financial information on Beibu Gulf, so as to enable him to value his interest in OSL and PBM. Now, the dispute of the financial information at the Beibu Gulf level is directly related to their attempts to split their business interests. So it is part of OSL and PBM. And of course, Mr. Chu was the managing director of Beibu Gulf, and Mr. Lau was a director. So why he couldn't just provide information to Mr. Lau was beyond us. And indeed, in the present case, it's even suggested that what Mr. Lau should have done was to apply in the Hong Kong courts as a director for access to that information. Well, if the relationship between him and Mr. Chu had broken down to that extent, then obviously that just proves the case. And we've set out at paragraph 135 onwards, we've set out in detail all the attempts to get financial information and the restrictions that were sought to be placed on Mr. Lau, including we couldn't take copies of documents, etc. That's at 136. And we say, this sort of tedious exchange is typical of the communications between Mr. Lau and Mr. Chu and their associates. And then Mr. Justice Kelly says, so it went on. And then he goes on, paragraph 138, the deadlock gets worse. And he recites the events from there to the commencement of proceedings in April 2015, by which time there were 7 sets of proceedings between the two of them. How anybody could say that this wasn't a deadlock case, I just can't understand. And even on the Court of Appeals limited matters that can be taken into account, the disputes in relation to the other companies all arise from the attempts to separate their interests, one of which was OSL and PBM. It's not possible to divorce everything that was going on from OSL PBM. They were trying to separate all the interests and they failed miserably. So that's even on the limited approach advocated by the Court of Appeal and ignoring the concession in the defense that a breakdown had occurred. There was more than enough to conclude, as the judge did, that there was an irretrievable breakdown and deadlock in relation to OSL and PBM by the time the proceedings were commenced. My Lord Hodge, I'm going on to a new topic. I know we're 5 minutes before the time. Do you want me to continue? You're muted, Lord.
The point you're making, as I understand it, is that in the lead up to paragraph 59, there was a finding by the judge that there had been an irretrievable breakdown before the commencement of proceedings on the 27th of May 2015.
Correct.
Yes, and that the Court of Appeal didn't address that.
Only to the extent that they used one example which was the PBM loan issue. And they therefore said that was at the baby gov level, it was entirely irrelevant.
Yeah. But but insofar as they went into the question of post-commencement events, and said that the judgment was vitiated by the consideration of that, did they face up to the fact that the judge had held by the 27th of May 2015 there had been an irretrievable breakdown?
They certainly don't expressly refer to that.
No.
Indeed, what they refer to, I can just take you quickly to that passage. Well, they first deal with it at 4373, paragraphs 54 and 55. I'll have to come back to the actual passage. It's a passage where they say that the judge based his judgment mainly on post-commencement events.
Yes.
And there is a passage to that. But of course, that's just not the case. Indeed, if you count the paragraphs numbers, not a particularly analytical way to do it. He spent more time on the pre-commencement matters than the post-commencement matters.
Yes.
Isn't that paragraph 54? Is that the passage you want at lines 2 to 4? 2 to 5?
At 54?
Yes. 54.
Yes, my lady, thank you. That's exactly the passage I was looking for. And that's just not an accurate summary of the judgment.
Well, that's why I was asking that question.
I'm sorry, I didn't get to that quicker.
No, because if you look at the judgment really from the late 30s, paragraph late 30s, by 2015 the two men started to disengage from one another, and then you have a finding about Mr. Lau being fobbed off in relation to information. And you've a finding of an assertion that the loans were capital, and then you've got a finding of further irregularities, and then in 54 a finding that in July 2014 Mr. Lau could no longer work with Mr. Chu. I was puzzled why what one had the assertion by the Court of Appeal in paragraph 54.
Well, that's my submission as well, my lord.
Yeah. Well, is that a convenient place for a 5-minute adjournment?
It is, and as I understand it, I have to switch off my video.
Yes, you could switch off your video and your sound if you wish, and then return in 5 minutes.
Thank you.
Thank you very much. Good morning. This is the Judicial Committee of the Privy Council. We are resuming the hearing in the case of Lau and Chu, and Mr. Philip Jones is continuing his submissions. Mr. Jones.
Thank you, my lord. There was one passage which I couldn't lay my hands on in my submissions this morning. My juniors have now found it for me. Could we go to 6092? This is from the speech of Lord Wilberforce in the Ibrahimi case. And you'll see right at the top of the page, secondly, it has been suggested and urged upon us that, assuming the petitioner is a shareholder and not a creditor, the words must be confined to such circumstances as affect him in his capacity as shareholder. I see no warrant for this either. No doubt in order to present a petition, he must qualify as a shareholder. But I see no reason for preventing him from relying upon any circumstances of justice or equity which affect him in his relations with the company, or in a case such as the present, with the other shareholders. My lords, my lady, I'm now going on to the topic as to whether I'm limited to relying on facts and matters that occurred prior to the filing of the application. The post-commencement matters which the respondent states must, as a matter of law, be excluded from consideration are usefully summarized in our written case at 5091. If I could ask you to go to that. You will see a heading, post-commencement allegations. And I know you will have seen this, but we've summarized them there. We've got paragraph 26. Mr. Justice Kay found that in January 2016, Mr. Chu, in breach of his fiduciary obligations to his partner, Mr. Lau and OSL, engineered a situation in which he or his associates, through BGAL, acquired the PLC holdco's 51% in Beirut Gulf, and thereby hijacked, and that's the judge's word, thereby hijacked the whole business venture to the exclusion of Mr. Lau. Similarly, in paragraph 27, he found that Mr. Chu, in breach of his fiduciary obligations to Mr. Lau as his partner in OSL, engineered a transfer of 6% interest in Beirut Gulf from BGAL to Polyrise, a company controlled by Mr. Chu and his associates, so as to ensure that meetings to remove Mr. Lau as a director of Beirut Gulf would be quorate. We then got the anonymous memos and change of directors. These were memos which came from BGAL, but were not signed by any individual or any individual acknowledging authorship. They accused Mr. Lau of numerous breaches of duty. Mr. Justice Kay found that Mr. Chu was, at a minimum, instrumental in their production. We then had 3 new directors appointed to the board of Beirut Gulf, and Mr. Lau was removed. Then we have the sale to Auska. The judge found that in order to frustrate any order the court might subsequently make, the ship chartering business owned by Beirut Gulf was sold for no discernible commercial benefit. And just quickly going down, further exclusion of Mr. Lau. In September 2016, Beirut Gulf opted out of the obligation to file business reviews for the benefit of its shareholders. And then, importantly, paragraph 31, the Lois transaction. This was only revealed when Mr. Chu filed his 4th affidavit on the 18th of April 2017. It was unsupported by any documentary evidence. Mr. Justice Kay's conclusions are at 70 and 71. He said PBM obtained convertible bonds in place of its loans to Beirut Gulf, which it then provided as security to Lois in respect of a loan by Lois to Beirut Gulf. As the judge found, this was done without Mr. Lau's knowledge and consent, and potentially, if not actually, altered the underlying value of PBM's rights and interests in Beirut Gulf in the terms of PBM's loans to Beirut Gulf. So these are the matters which the respondent Chu says must be entirely excluded from any consideration at all. And this is all based on what they call the rule in a Shelby. Now, we have 2 answers to this. First, with the exception of the Lois transaction, Mr. Justice Wallbank on the 22nd of March 2017 expressly permitted Mr. Lau to rely on these matters. And there was never any appeal on these points. The Lois transaction wasn't even known about at that time. That was provided by Mr. Chu 2 weeks before the trial. Second, however, we say the point is bad as a matter of law, and I'll just briefly deal with the second point first, if I may. So I said it depends on the ruling as Shelby. And so the effect of that is, of course, that if it's right, you completely ignore the matters that I seek to rely on during the 2 years before the actual trial. because the proceedings were commenced in May 2015, and the trial didn't take place until May 2017. Oh, I'm sorry, Lord Legate.
If the point were right, Mr. Jones, what you should have done, seems to me, is that at the time the judgment was given, issued a new winding up petition. Then the judge could have ordered that all the pleadings and evidence stand as pleadings and evidence on the new petition. And the judgment then could have been entered, because there wouldn't have been any, there would have been an issue estoppel, in fact, on all the findings and issues.
Yes.
So it's quite hard to think of a more technical argument.
Well, could you go to our written case, where we make that point, that exact point, where before Justice Warbank, there was no suggestion that we couldn't rely on those matters. The points that were being made was that, well, you've already got 15 matters of breakdown, it doesn't add to the case to add another 10, and that there wasn't time to deal with it. But this point wasn't taken. And is this our case? So 5093. We deal with the, we put in provisions in the judgment of Justice Warbank where he said, you don't need to amend, it's not necessary, I'm going to allow the evidence in. And at paragraph 38, at the bottom of this page, what we say is if Mr. Chu had taken the point that only matters that had occurred prior to the commencement of the proceedings could be heard on the winding up application, and Justice Warbank had considered that a good point, i.e. the Shelby point, a new winding up application could have been filed relying on these points, and the affidavits already filed by Mr. Lau, it would have been a straightforward and simple exercise that would not have been costly or time consuming. As Warbank J considered, there was sufficient time before trial for these matters to be dealt with at trial. We would simply have ordered it to be heard at the same time as the existing application. It was wrong for Mr. Chu to take the point subsequently, as there was no appeal, and Mr. Lau acted to his detriment by not issuing a new winding up form. So, you know, I don't know how much time you want me to go through, Shelby, because that seems to me to provide the answer at any event.
Well, it's what masters used to do, in my recollection, when a Shelby was thought to be good law, and you wanted to bring in a claim for a sum that had accrued after the writ had been issued. You'd issue a new writ, and the master would order that all the pleadings and proceedings would stand in the new action, and the two would go forward together.
My lord, that's exactly what I've got in my written submissions. I was saying that those of us who practiced in England are familiar with this issue, and not just under the older Shelby rule, but you know, when you've got a limitation issue, if there is an arguable limitation issue because of the backdating of the amendments, the course of action is to issue a new claim form and then consolidate it. You know, the rule in Shelby has absolutely nothing to commend it whatsoever. And we say in a modern procedural code with an overriding objective, you know, it's just a piece of historical dust.
It strikes me finding up order on the just and equitable ground, although of course statutory, is awfully like some form of equitable discretionary relief. Does the rule in has the rule in Shelby ever been applied to equitable relief?
Gosh, I'm not sure I can give you the answer to that on my feet, except I'm not on my feet.
It seems instinctively very strange that a court which is being asked to exercise a discretion should be required to exclude facts which have occurred between the commencement of the proceedings and the date when the court decides whether or not to act.
My lord, I agree. I think in the light of this, I need to take this very quickly, if I may. Just to Shelby was, just briefly, there was an agreement to pay a sum of money in 4 equal instalments. The first instalment was not paid. A writ was issued. By the time of the trial, the second instalment had fallen due. At the trial, the official referee permitted the plaintiff to amend the writ to include a claim for the second instalment. On appeal to the divisional court, they held the official receiver had no power to permit an amendment, which introduced a new cause of action that did not exist at the time the writ was issued. And if you go to 5113, no, I don't need to take you to that. I think we can go to 6149. And this is from the judgment in the Shelby, and I just need to take you to the particular rule of the Supreme Court as it then existed. You know, the court or a judge may at any stage of the proceedings allow either party to alter or amend his enforcement of pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. And my lords and my lady, you know, I say that with those sort of wording in a modern court today would have no difficulty in reading that as including a power, if appropriate, to add a claim to a case that had occurred subsequently. Obviously, one's got to take into a question's limitation, but that's how you exercise the power. What we're dealing with is the question of whether there should be a power. There's nothing to commend at Shelby at all. And what happened was in 1962, the rules of the Supreme Court were amended to make this clear. And if I ask you to go to 6569, this is the decision of Henry in charge search. And if you scroll down to 21, you'll just see what the rule was at that time. You know, subject to certain rules which are not material for present purposes, a party may in any pleading plead any matter which has arisen at any time, whether before or since the issue of the writ. So that was introduced in 1962. Now, in the modern English CPR, there is no equivalent to that. What one's got is a wide discretion and Rule 17.1. We've put all the relevant stuff from the CPR in the supplementary bundle. We don't need to go to it. There's just a wide power, and we've got the overriding objective. And, you know, I just make the submission, there's no way a modern court would be constrained by the Shelby restriction. And indeed, in a case called Maradiv, the Court of Appeal considered the matter under the CPR and simply said that the approach in Henry and Chart search, which we were just looking at, sorry, I didn't introduce the name of the case, just represents the modern approach. And you see that at 6956. If you go down to paragraph 22, letter G,
this is Murray Drive and Dive and Oil Services. Yes.
Yes.
Sure.
They deal with Henry and Chart search, and they just take the paragraphs which say, you know, this is the general approach, and they apply it. And you probably need to just go over the page. But of course, that's just, we've also included in the supplementary bundle the equivalent rules for the Eastern Caribbean CPR. But of course, that's at a general level. Actually, what one's dealing with here is tailor-made provisions for just and equitable winding up, both in the Act and in specific rules under the insolvency rules. So ultimately, it's going to turn on a construction of those. So 5257, number of points I have to make here. This is the Insolvency Act and the BVI. And if I can ask you to go to, sorry, I typed in my wrong reference, 5247. This is the BVI Act. And if I can just go to 160, where it says the liquidation of a company commences at the time at which a liquidator is appointed, as provided in section 159, and continues until it is terminated in accordance with section 232. So that's different to the regime that exists in the UK and many of those countries that derive their company law and insolvency law from the UK, where the commencement of the liquidation backdates to the date of the presentation of the petition. So, one can see a potential argument that an applicant in those jurisdictions which adopts the backdating of the commencement of the liquidation might be limited to making out its case on the facts and matters as they existed at that time. That isn't, in fact, a position adopted in the UK, however, and we've cited the Walter Jacobs case and the Fidelis case, which I'm not going to take you to. However, where the liquidation only commences when the order is made, appointing the liquidator, such as in the BVI, the potential problems re backdating no longer exist. So there's no conceptual reason why an applicant cannot rely on matters that have occurred subsequent to the filing of the application. Of course, one has to properly give notice of any matters that one wishes to rely on, but that's a separate issue. What we're talking about here is jurisdiction. And then if we go to 5248, first of all, you've already seen this, but section 162, what the court is directed to do is to determine whether it is of the opinion, that's present tense. So that we say is directed to the date of the hearing. And then if we can look at the specific rules that have been made for these proceedings. So if you go to 5255, these are the rules, and what I think I can go straight to is 5261. And we've got rule 168. This is a specific rule to deal with applications for the appointment of a liquidator made by a member of the company. So it says that it has to be in standard form, that is just a originating application and a supporting affidavit. And then subparagraph 4, a member shall not, except as directed by the court, be served on, member's application shall not be served on any person other than the company or be advertised. And then this is the important bit. At the first hearing of the application, the court shall give such directions concerning the procedures for or in connection with the determination of the application as it considers appropriate. And then it says, without limiting 5, the court shall give directions concerning the service of the application on or giving notice to other persons, whether the application should be advertised, and then C and D. C, whether a statement of claim and defence and reply to defence are to be delivered, and D, the manner in which evidence is to be adduced at the hearing of the application, including the matters to be dealt with in evidence. There's no requirement for pleadings. The court, wide discretion given to the court as to the procedure to be adopted. Now, obviously, the Rule 4, which I'm afraid is in the supplementary bundle because we omitted it, says that the CPR applies except for certain provisions. And what it excludes are the provisions relating to statement of case and amendments, including those. So what we've got here is a self-contained procedural rule, which by necessary implication also includes, as it were, revising or amending directions that have been given at the first hearing. So, that plainly, taking into account the nature of the legislation, it's directed to the time of the hearing. The suggestion that this has to be read subject to some shall be rule, we say is ridiculous. It gives the court a very wide discretion. And the orders that Justice Warbank made were perfectly within the jurisdiction.
Do you have the MS number for his order?
Can I just ask my juniors to do that, and then I'll come back to it?
You can give it to me after the short adjournment.
Well, I'm sure I can give it to you. If the Shelby rule excludes me from relying on matters after the commencement of the proceedings, then surely it must also follow that it precludes the defendant from relying on matters. But what the defendant wants to do, and we'll come on to this, is to rely on the board meeting of the 15th and 16th of December, but exclude the contemporaneous lowest transaction and hijack. That's what they're trying to do. My learned friend refers to the mineralogy case in Western Australia. He'll no doubt take you to that. But the second ground relied on, which he doesn't take you to, is that, even though if a Shelby is binding, then it's the point that Lord Leckett has just made. He said, well, we just issue a fresh claim form. That went to appeal. It then subsequently came back to him as to whether to consolidate. And I'm sorry, this is in the supplementary bundle, the following case. Can I just read out two short passages rather than go to it? Paragraph 15, he describes it as, the problem, if there is one through the Shelby principle, is only a lawyer's fine point. But any problem is capable of being procedurally ameliorated, even in Western Australia.
Could you give us the page number from the supplementary bundle, please?
Yes, 98.
Thank you very much.
Somebody's shouting at me that. 90. And then the following paragraph 16, as a matter of justice and sensible case management, it seems to me that it is fully appropriate for consolidation orders to issue as sought. So I'm now going, there's one more matter. They say that you are bound by a previous decision of this board to hold that Shelby is the correct way to approach this. Hopefully I can take this in a few minutes. If you go to 6041, this is a decision of this board on appeal from Australia and Davis and Brunswick. And if I can ask your eyes to glance down about sort of a third to halfway down, do you see a sentence saying, holding an even hand? If everyone sees that sentence, it says, holding an even hand between the two conflicting interests in the present cases, their lordships are of the opinion that the decisive question must be the question whether at the date of the presentation of the winding up petition, there was any reasonable hope that the object of trading at it that the object of a trading at a profit with a view to which the company was formed could be attained. Now, it said that because of that passage, that binds you to look at questions as of the date of the presentation of the petition. Well, the date at which one asked that question in that case was simply not an issue. Indeed, the petition was presented on the 8th of July 1932, and it was wound up on the 9th of September 1932. The court was not addressing the question of when the question should be asked, but what was the relevant question. But there's nothing in that case. What I next want to move on to is Mr. Chu's case on the hijack, just to see what it is that he says. You've already seen our written summary. What Mr. Chu says about these findings are at 5176. And if you scroll down to the bottom of the page, paragraph 116, first, they tendentiously refer to them as the non-pleaded issues, when we were expressly dispensed with pleading them, all of which they say formed no part of the appellant's pleaded case. Well, of course not. We were given an express dispensation from amending the pleadings. 2 arose after the petition date. Well, that's the Shelby point. There's nothing in that. And 3 were raised by the appellant very late in the day and almost on the eve of, or even at the trial. And 4, the respondent only had a limited opportunity to deal with it. Well, importantly, no evidence was contained in Mr. Chu's 4th affidavit as to any further evidence he would have liked to have put in, but had not been able to do in the time available. He was permitted to file 3 affidavits. This, of course, was an invite for him to file evidence from the so-called BGAL owners and directors to demonstrate that they were independent of Mr. Chu. He didn't. He never said that he would like to have called them, but he was not able to do so because of X, Y, or Z reasons. Even today, they've still not said what additional evidence they would have adduced had they had further time. Then we read on. So in part, the judge's findings involve speculation on his part or inferences drawn in relation to matters on which he actually makes no finding. And they refer to 74, which we'll go to in a moment, where the judge draws an adverse inference against the respondent as to the connections with BGAL, whilst expressly emphasizing that it was not necessary for him to make any decision on the point. In this regard, it's notable that the judge places particular weight on the fact that the respondent was a director of BGAL when he was not, and it has never been any part of the appellant's case that he was. So if we go to the page 24 of the electronic bundle so that we can see the judgment at paragraph 74, so if you go to 74, this is what they're referring to, and we need to go through this carefully. So Beibu Gulf accordingly decided in January 2016 to sell out their 51% shareholding to BGAL, which Mr. Lau, for understandable reasons, thought might well be closely connected to Mr. Chu. Although given an opportunity to deal with these matters by the order of Wallbank J, Mr. Chu declined to call any evidence from BGAL, such that in my judgment, the court is entitled to draw adverse inferences against Mr. Chu as regards this episode. Now, the adverse inferences that he draws are to be found if you go to page 27. And if you look at paragraph 81C, these are the adverse inferences. Mr. Chu has managed to engineer, in my judgment, a situation whereby he or associates of his seized effective overall control of Beibu Gulf by BGAL and Polyrise in order to exclude Mr. Lau from any participation in management. All this was done or engineered by Mr. Chu without properly or fully informing Mr. Lau. So those are the adverse inferences he draws from those first two sentences. That's what this follows from. If we can now then go back to page 24, and we go to that paragraph 74, sorry. So, sorry, my computer's telling me updates are, dear. Oh, no. If we then go on to the second and third paragraphs, Mr. Chu seems, apart from any other connection he might have, to have been a director of that company. It is, I emphasize, not necessary to decide this latter point, nor the next. But as Mr. Jones submitted, it is at least arguable that since Mr. Chu acquired an interest in Beibou Gulf through his connection with PBM, and of course with his partner Mr. Lau, he did not disclose these matters fully or properly, he and Begal hold a 51% interest on trust for PBM. So the judge says he does not decide either of those two issues. What he is deciding, however, is that Mr. Chu has effectively hijacked Beibou Gulf, either being the owner of Begal or his associates. So the first two sentences lead to the conclusion that we've seen in paragraph 81C. But there's nothing in these criticisms at all. If we go back to 5177, it refers to Ausker. Now, the important part with Ausker is that the judge found that there was no evidence that Beibou Gulf had received any consideration. That's the important part with Ausker. My lords, I'm going to have to now move on, but the point I'm making is that there is no substantial grounds for interfering with the judge's conclusions on the lowest transaction and the Beibou Gulf hijack. And in fact, what's noticeable about the discussion section in the Court of Appeal's judgment, you get no reference to it at all for either of these matters. What I next need to deal with, and because time is running out, is what obviously Mr. Chu thinks is his best point, which revolves around the Beibou Gulf board meetings of the 15th and 16th December 2015. And we have set out in detail the connection between this and the virtually contemporaneous Loas transaction and hijack at our reply submissions at 2510 to 2513. As I say, the respondent's case is that the secret Loas transaction, and it's not in dispute that it was never revealed to Mr. Lau until 2 weeks before the trial. Their case is that the secret Loas transaction was necessary because Mr. Lau refused to implement the 15-16 December agreement. And he goes as far as to say that because of Mr. Lau's position, he's not come into this court with clean hands. In fact, the responsibility is the other way around. The Loas transaction was secretly implemented on the 28th of December 2015. It does not implement what Mr. Chu says was agreed at the 15th of 16th December agreement. And it was done before even Mr. Chu dates the time at which he says he realized that Mr. Lau was not going to implement what he says was the agreement. And all this was done to make sure that the ships were kept at the Beibou Gulf level and didn't go to the PBM level. I think I've given you a wrong reference. The correct references are at paragraphs 277 of page 36 of our, I think I should have given you a reference of 5210, where you find in our reply submissions the detailed points. I'm sorry about that. Now, let's just see what the
5210 is the Bebu Gulf AGM.
Well, what I want you to next go to, I'm sorry, I've got some of these, I got one of these references wrong. I don't think much time on it. Could I ask you to go to 760? This is it's the resolution of the board meeting of Bebu Gulf. Now, exactly what happened at this meeting is a huge matter of debate, but let's take it at face value for present purposes. And what I want you to do is to scroll down the page, and the relevant one is 3.1.
Could you repeat the reference, please, Mr. Jones?
Yes, 706.
706. Thank you.
I'm sorry to interrupt. It's due to a broadband failure. I'm now reconnected on what I hope is a better signal.
Well, Lord Briggs, can you catch up from the transcript, perhaps?
I'd be perfectly happy to do so.
Yes, we're looking at the question of the Bebu Gulf board meeting of the 15th and 16th of December 2015.
Yes.
And,
706.
we're looking at 706.
Thank you.
The relevant parts of the resolution are 3.1 and 3.2. It's not easy reading because, of course, it's a translation from the Chinese. But essentially under 3.1, two of the vessels, Bright and Endeavour, at this time they had 4, two of the vessels are going to go to the PRC interests. And then the important one is over the page at number 2. So, as PBM indicated that it cannot execute the arrangement to purchase the 2 single vessel holding companies at the moment, it's agreed that the company would utilize the shareholders' loans from PBM to repay the outstanding sums from the loans from Credit Suisse and the related fees due to the advanced repayment regarding Glory and Hope, because they use them in that order, whereas we would naturally call them Hope and Glory. So regarding Glory and Hope are the 2 other vessels owned by single ship-owning companies that were to go to PBM. So PBM would utilize its shareholders' loans to assist both shareholders to release the guarantee liabilities arising from the finance documents of Glory and Hope. The remainder of the sums of the shareholders' loans from PBM and the company would be held on trust. After PBM pays the company the difference in value for the 2 single vessel holding companies, Glory and Hope, that's the single companies, would be completely owned by PBM. Now, to try to break that down into simple terms, the Bebu Gulf had the loans outstanding to Credit Suisse. Part of the PBM loans would be used to pay that off to enable the other 2 vessels to go to the PRC interests. That would leave a sum outstanding to PBM, which they say would be held on trust. Nothing turns on the word trust. It's a translation of a Chinese word, and whether they were intending the common law concept is not known and doesn't matter. But that would not enable PBM to purchase the Hope and Glory. They would need an additional sum of money. Mr. Chu says that that was $18 million, and for present purposes, I'm happy to recognize that. So what was envisaged was that PBM would come up with additional money, and the 2 vessels would then be transferred to PBM. We then need to look at what the lowest transaction was, and Mr. Chu only revealed its existence on the 18th of April. Sorry, can somebody quickly give me the reference to Mr. Chu's fourth affidavit? 413, thank you. Sorry, we're just having a debate here as to which paragraph it is. Would you bear with me? I'm sorry about this. The one where it's got four subparagraphs, which describes the lowest transaction. Right, 414. Oh no, Junior is right. Sorry, can we stay on 413 and paragraph 82? This is Mr. Chu. As I said, contrary to his agreement in the board meetings, Mr. Lau took no action and did not seem willing to provide his 50% share of the shortfall of $18 million. In order to preserve PABN's position to acquire, that's got them the wrong way around, PBM acquire Hope and Glory, I had to come up with a solution myself. Based on Mr. Lau's email of the 12th of January 2016, I had to expect that Mr. Lau would not act in a constructive manner to resolve this issue. No doubt I was put into a very difficult position. The matter needed to be resolved without delay. And what we then go on to the next page is what the details of the lowest transaction. Just remember, what he is saying is that as a result of the email of the 12th of January, which, can we just go to that email just for the moment and come back to this? So we'll come back to 414. If I can ask you to go to 2565. This is the email that is referred to by Mr. Lau, but Mr. Chu, as an email from Mr. Lau. So what Mr. Lau says is, regarding the proposal for Beidou Gulf selling all its shareholdings in Hope and Glory to PBM, I agree in principle. However, if the shares of the two single-owned vessels companies were transferred to PBM Asset, in view of the serious disputes between you and me, you and I cannot realistically resolve to operate these two vessels through PBM Asset normally. This had been made clear at the board meeting of Beidou Gulf on the 15th and 16th of December, where it was agreed that you and I should take one ship to operate separately in the end. Therefore, you and I should now appoint a company each to purchase one of the single ship companies, each from Beidou Gulf, and after the share transfer, operate one own ships separately. So that's the email that he says. He drew the conclusion that Mr. Lau was not going to implement the agreement, and therefore that explains why he secretly had to do the lowest transaction. Now go back to 414. This is the description of the lowest transaction. And of course, he never produced any of the background documents. So we have no idea of knowing whether this is what happened. And so accordingly, this is what he says. A loan of approximately $18 million to be repaid within 4 years, guaranteed by Beidou Gulf, would be advanced from Lois in order to fully discharge and settle the said shipping loan. The shares of the single-owned vessels would all be charged and mortgaged. For the purpose of reflecting PBM's special interest in Hope and Glory, as well as true nature of the fund as shareholders' investment capital, Shining and Palace would each issue to PBM convertible bonds of approximately $18 million. And then upon PBM's repayment of the loan from LOAS and settling liabilities in connection with the two vessels arising out of the maintenance and operation needs, these converted preference shares mentioned in B above could be further converted into ordinary shares. Now, I have difficulty understanding that, but then so did the judge, because we were never given the underlying documents. But the significance that we draw from that is that what ultimately happened was that PBM converted its loans into convertible bonds, which it's then granted as security. But importantly, unlike what was set out in the resolution, the vessels remained at the Bebu Gulf level. They don't come down or go up to PBM. Now, the problem, and of course, what we said was that, one, he didn't want us to understand the transaction, but importantly, he did not want us to know when, in fact, he'd entered into all this. Because, in fact, it was entered into on the 28th of December. And we caught him out on that because one of the documents exhibited had a line which revealed that. So if you go to 5672, 2672, sorry, 2672. Yes. This was amongst the huge exhibits, which was a demand on August 12, 2016. It says, we refer to a repayment notice, and you read down and you'll see a reference to clause 15.1 of the loan agreement dated 28th December 2015. There was a lot of cross-examination, but he did accept that the cross-examination, I think it's about 80 pages. You find it at 3850 to 3933. And I'm not going to ask you to turn it up, but at 3872, it's accepted that the lowest transaction was entered into on the 28th of December. And indeed, on the chronology, the agreed chronology before the board, that's also agreed as the date. So what is clear is that, and you remember the 16th of December was the second of the two dates of the board meeting. And the 28th of December is the date of the lowest transaction. And that is only 6 clear business days after the board meeting, because Friday the 25th of December is Christmas Day, which is a public holiday in Hong Kong. Actually, also Boxing Day is a public holiday in Hong Kong, but that fell on a Saturday. And I think, unlike us, they don't move it over to the Monday. So you know, it was absolutely clear that the email of the 12th of January was not the cause of all these transactions. They were obviously planned at the same time. Similarly with the hijack. So the suggestion that it's Mr. Lau who hasn't implemented that board resolution, and that he is not coming to the court with clean hands, we just say is absurd. As with so much of this, it's Mr. Chu that causes the problems. Now, the other point we want to make is that it's common ground that this was all done without Mr. Lau's knowledge and consent. How PBM was able to take convertible bonds and grant security of the bonds without Mr. Lau's participation was always a mystery. Could not hold a valid board meeting without Mr. Lau. Now, I put it to Mr. Chu in cross-examination that somewhere along the line, he must have forged Mr. Lau's signature, because it was not possible otherwise with to have implemented that. But the judge didn't make any finding on that, and nothing really turns on it, but it just illustrates the point, as we'll see in the judgment, that we couldn't, neither the judge nor I could work out how on earth this transaction had taken place. But the fact that Mr. Chu did not disclose to Mr. Lau what he had done on behalf of PBN for another 16 months, shortly before the trial, is about as good evidence that one could ever need that there was an irretrievable breakdown and deadlock. It had simply not been discussed, and he kept it secret from Mr. Lau. We've already seen that the way it was structured kept the vessels at the Beirut Gulf level and did not distribute them to PBN. And this, of course, Mr. Chu did not want PBN to be in control of these two vessels. One also has to remember that at this time, the first trial was fixed to start on the 9th of March 2016. The last thing Mr. Chu wanted was to lose a trial and find that the liquidators were in effect in control of the vessels. We've set out quite a bit of learning on the clean hands. In particular, the Vujonovic case seems to us to be a killer, even if we're wrong on the analysis of the facts. And that's at 5199, paragraph 22. I'm not going to ask you to turn it up, I'm running out of time. Next, we need to see what the judge made of all this. If we can go to page 22. So we've got to read really from 67 to 72. If I could just ask you to please just skim read it. Can I continue? Yeah. Let's just see what the Court of Appeal said about all this. Well, first of all, it says absolutely nothing about the lowest transaction or the hijack. If we can go to 4376. We've got paragraph 60. I accept Mr. Hacker's position that if the court is able to take into account the evidence in other companies, there is cogent and objective documentary evidence that points to there being no deadlock in relation to OSL. There were documents which evidence negotiations after the date of the application, and that both gentlemen met, were engaged in discussions with each other, and were able to take effective decisions regarding PBN. There were actions between the two men that clearly show that there had not been that level of breakdown which constitutes a deadlock. In my view, therefore, is that the judge was plainly wrong in holding that there was a deadlock. And of course, we're just not told what documents they have in mind, nor what parts of documents. One might have try to be a bit fairer for the Court of Appeal. There is a further passage in the Court of Appeal which might identify it as being around the board meeting time that they had in mind. Ah, yes. If we go to 4379, and you go to paragraph 68, this is in the alternative remedies section, but they say, I applied above principles to the case of Barr, and I agree with Mr. Hacker's submission that the judge should have decided whether or not at the time of trial, in all the circumstances, it was just inevitable for the company to wind up. The evidence shows that several months after the filing of the application, the two gentlemen were still engaging in conversation and trying to find a way to work out the differences. That hardly justifies the appointment of a liquidator. So this may be the sort of what they're talking about at the earlier section, and it would seem it's clearly about the few months after the commencement of the proceedings, so it's likely to be the board meeting. But that's what we know, it's guesswork. But the suggestion that because of that resolution, that showed that these persons were able to cooperate without taking into account the lowest transaction, the hijack. In respect, this is staggering, because for the last 16 months before the trial, Mr. Chu had hijacked Beibu Golf in breach of duty. How can these parties be expected to resolve the issues in relation to PBM? What this cried out for was, a management decision at PBM to investigate what has gone on and to bring proceedings. But Mr. Chu and Mr. Lau were never capable of reaching that decision, which is why this case cried out for liquidators. But why the Court of Appeal doesn't even mention the secret lowest transaction which PBM entered into, I don't know. It may be that what they've done is to just exclude all the matters in our favour after the commencement of the proceedings and just looked at matters in the absence of them. But you end up with an Alice in Wonderland world.
But courts treat winding up as a measure of last resort.
Yes.
So what the Court of Appeal may have had in mind was that there were other ways of resolving this.
Maybe, my lady, but we just say there weren't any other ways of resolving it, because any other way of resolving it required the agreement of Mr. Chu and Mr. Lau. But I'm going to come on to alternative remedies. But I take my lady's point.
Yes, I agree. You've got to come on and deal with that yet.
I haven't, and I'm really running out of time. I've got 25 minutes left, and I know from my alternative remedies, it's about 40 minutes I need. So I've got to get a move on. Without this board meeting issue, there's nothing in the other side's case. They spend 10 pages sort of island hopping tiny little bits, most of which is just wrong and out of context. And we have set out 17 pages of response to that at, I'm going to quickly give the reference.
Is it your response document?
It's our reply documents, and it's
5193.
Oh, thank you. And it's there are 17 pages there, and I obviously just can't do that. It's all set up there, our response to their case. So I'm 5201 is the beginning of what I say are our 17 pages that deal with it. So I've quickly now got to go on to alternative remedies. So to go back to the questions that have to be asked, we say that looking at the state the company was in, and on the basis that there were no other alternative remedies or solutions, this is a case that clearly required the appointment of a liquidator. Having established that, the onus is then on the respondent to establish that there are alternative remedies or solutions available to Mr. Lau, and that he is acting unreasonably in seeking to have a liquidator appointed instead of pursuing that other remedy or solution. Let's remind ourselves what the judge said at this, page 33. It's paragraphs 96 to 97. Can I just emphasize 2 points there in 96? First, the sentence, Mr. Chu demonstrated by his own conduct in repeatedly obstructing and deferring any final settlement and implementation of the restructuring agreements, that an alternative to liquidation by arrangement between the parties is simply unlikely. And the second point, in the last sentence, in any event, Mr. Chu totally failed to show he had the means to buy out Mr. Lau, even if he had the inclination, which I do not believe for 1 minute. Can I ask you then to go to the Court of Appeal judgment at 4380? And if I could ask you quickly to skim read 71 to 75 to see what the Court of Appeal said. That's the entirety of it. Just if I can pick up some points. Paragraph 71, the Court of Appeal gets the burden of proof the wrong way round. They say it's on Mr. Lau, we say it's on Mr. Chu. When you get to 72, you find the suggestion that there should be some adjournment with directions given for Mr. Chu to buy out Mr. Lau's shares. But at the end of 75, they say they would order Mr. Lau to offer for sale his shares to Mr. Chu or to an interested party. There is no jurisdiction in the court to make such an order. On a just and equitable winding up, you do not have those powers. The law would be better if extra powers were conferred so as to make different orders on the just and equitable winding up application, but the court doesn't have power, and I think that's common ground. What my learned friend says the Court of Appeal actually decided, and I submitted all that to the Court of Appeal, but there's no reference to it. What my learned friend says about the orders that the court made is at 5182. And if you go down to the bottom paragraph, that's the one I'm going to take you to in a moment. So it says the argument in our case appears to proceed on the basis that the Court of Appeal erroneously made a buyout order when it had no power to do so under Section 162. However, it's plain that it made no such order from the terms of the order drawn up after the decision, although the judgment might be read as suggesting that such an order was intended. Any fair reading of the judgment and subsequent order taken together made it clear that the Court of Appeal was doing no more than stating that it regarded a sale by the appellant as an available alternative remedy, which precluded the making of a winding up order. So let's look at the order that's actually made by the Court of Appeal. If you go to 4386. Now, of course, the Court of Appeal made no order at all in respect of the alternative remedies because it had found that there was no deadlock. So what the order says is the appeal is allowed, the order winding up OSL and appointing liquidators over OSL is set aside. But that, of course, follows from its answer to the first question. It doesn't say anything about alternative remedies. It didn't need to. So how my learned friend gets assistance from that as to his interpretation is a mystery. What is clear is that they made an order which they didn't have jurisdiction to do. But then let's consider what they actually suggested should happen. Now, the suggestion that Mr. Lau should sell his shares to an interested party, let's take that first. There was no evidence that there was an interested party. What would happen if Mr. Lau put the shares on the market and there were no interested buyers? We're again back to square one. The reality is that nobody was going to pay a sum equal to 50% of the value of OSL to step into a structure which Mr. Chu had hijacked and in respect of which nobody knew the value of what it was. Importantly, however, this possibility was not put forward in the defence, was not explored in the evidence. As you will have seen from the question put to me, or the statement put to me by Blenman, J.A., which is at 5125, This is a quotation from the transcript in paragraph 167. You know, when I made what I thought was an obvious point, we got the following. How do you get there? How do you get there? I'm not sure. How do we come to that conclusion? And on what basis? If you have a company that's valued at $1 million, 50% each, how do you determine that if there's a breakdown and you have to sell half, the person who is buying the share would not be able to get the real value of the shares? How do we get there? Anyway, I'm not going to say any more about that. Yeah. But importantly, again, as my Lady Arden made in Chand again, the general rule is that you cannot criticize a judge for failing to take into account something that's not put to the judge. This wasn't put, never suggested to him, no cross-examination in respect of this issue. Now, as regards an order that Mr. Lau offer his shares to Mr. Chu, the judge had already found as unchallenged fact that Mr. Chu did not have the means or the inclination to buy the shares. You know, those findings were not challenged before the Court of Appeal. How, in the light of this can be an appropriate order is bizarre. Now, however, if you go to my learned friends, I notice the time. Am I going to be stopped there, my lord?
Yes, that probably is a convenient place to stop. You'll have half an hour on your return, Mr. Jones.
Well, I think to be fair to my learned friend, we'd agreed 2:15. Is that right?
Oh, have I got the time? I will check the sheet. Maybe the sheet is not accurate. Is that the agreed?
Oh, apparently I've got 2:30. I didn't realise that.
Well, my understanding from the case sheet is you have until 2:30.
You're right.
Okay, we will adjourn now and resume again at 2 o'clock. Thank you very much.